the information that you're seeking now to introduce through Mr. Connor, I do have an authentication issue about it. 90.901 is the requirement for authentication or identification. 90.901A, 901.1A, and I'm reading from Earhart. The most common method to authenticate the electronic record or message is by the testimony of a person with knowledge who created the record or message of that printout accurately reflects the contents that the witness created or sent. And it goes on and it brings you to footnote number 3, and it references Griffin versus State, 419 Maryland, 343 19A 3rd 415 2011, and State versus Ellick, ELECK, 130 Connecticut Appeals, 632 23A 3rd 818, 2011 case. An electronic document, example, email, text messaging, and networking sites like Facebook, may continue to be authenticated by traditional means such as the direct testimony of the purported author or circumstantial evidence of distinctive characteristics in the document that identify the author. Typically, electronic messages do have self-identifying features. For example, email messages are marked with the sender's email address, text messages are marked with the sender's cell phone number, and Facebook messages are marked with a username and profile picture. Nonetheless, given that such messages could be generated by a third party under the guise of the named sender, opinions from other jurisdictions have not equated evidence of these account usernames or numbers with self-authentication. They cite another case of Commonwealth versus Purdy, 459 Massachusetts, 442, 945 Northeast 2nd at 372, 2011 case. Evidence that electronic communication originates from email or social networking website that bears purported author's name is not sufficient alone to authenticate it. Another case, they cite emails authenticated not only by defendant's email address, but also by inclusion of factual details known to the defendant that were corroborated by telephone conversations. And my point being is that what has been presented to the court, Exhibit 2, Exhibit 4 is the profile picture. Exhibit 2 and Exhibit 3 has nothing identifying Mr. Martin. He doesn't say, hey, this is Trayvon, or it has going out to Lavandria, coming back in from Lavandria. It has the phone numbers, it has the time, but anybody could have picked up that phone and sent these text messages. A third party could have access to it. People have children who pick up their phones and play with them and send text messages to their friends or other people. I don't have any identifying marks that these text messages are created by or sent by Mr. Martin. I have a concern about that.
Well, we know the phone had a double level of security. We know that.
And I know any 7-year-old can learn the passwords and get into that because they do it all the time.
FDLE couldn't do it for a year almost.
Well,
they sent this phone all over the country, and they had to write code for it.
but a person may know that password. Another person may know that password. FDLE didn't know the password.
Right, it's evident under 90.901 that there's evidence sufficient to support a finding that it is what we claim it to be. All of this came off of Trayvon Martin's phone. There are thousands of pictures, thousands of text messages, no indication that anybody else was using his phone. Mr. Connor looked at all of those text messages. Further, under the authority of is it Manuel?
Yeah, it's on the same page.
Manuel v. State, is that the one you're talking about? 357 Southwest 3rd, that one?
Yes.
Cited in Earhart's book, I guess, Mr. O'Mara pointed this out to me. to suggest. I don't know what else we could do under these circumstances when the state didn't give us the information timely.
But
We
even if
didn't-
the state gave you that information, is my point, what on these text messages identify that they were created by Mr.
We
Martin?
would have had the time and the opportunity to find the witnesses on the other end, first of all. And we have not had that because of the state withholding valuable, exculpatory, probative evidence in this case repeatedly, and then misrepresenting to the court what they did. And then finally, when we caught them doing it, we get it on June 4th. Judge, I don't know what else we could have done, frankly. We asked for time. We wanted to depose Steve Brenton. We asked the court to delay the case a few days. I don't know what else we could have conceivably have done under the circumstances to further this authentication issue under the circumstances that the state is solely responsible for. It's simply unfair for Mr. Zimmerman not to be able to put on his defense because of the state's tactics. It was a strategy, obviously, because they had it in January and kept it from us, made us spend 10, 20, 30, 100 hours digging it out, playing games with us, lying to this court, and now it's our fault. It's our fault. To deny Mr. Zimmerman the right to present this information violates both the Florida and the United States Constitution. Thank you.
Does the state want to respond?
Judge, not in substance, but because Mr. West said, I would offer him the opportunity right now to apologize to me for suggesting that I stood by silently with information that I did not have.
I'm not getting into this. Court is in recess. I will give my ruling in the morning. I'll see you at 8 o'clock in the
Your Honor,
morning.
may
Court
have-
is in recess. It is
It's 10 o'clock at night.
9:56.
Okay.
No, court is in recess. Thank you very much. With all due respect, we'll see you at 8 in the morning. Well, at 8 in the morning, the issue is Mr. Donnelly, who may have violated, or counsel has informed the court that you know that he violated the rule of sequestration. That's the second time today that I've heard that there's been a violation of the rule of sequestration by the witnesses. I don't want to take that up at 9 o'clock and have the jury sit out there and wait like they did today. We will be in recess until 8 in the morning. And so have I.
Not being able to prepare or get my witnesses gathered for tomorrow, and I can't do it tonight.
I'll see you at 8
Judge,
in
I'm
the
not
morning.
physically able to keep up this pace much longer. It's 10 o'clock at night. We started this morning. We've had full days every day. Weekends, depositions at night.